Justice Sandra Day O'Connor recently quoted Oklahoma Supreme Court Justice Jean Coyne, who was asked, "Do women judges decide cases differently by virtue of being women?" Justice Coyne replied that in her experience, a wise old man and a wise old woman reached the same conclusion.
Welcome back to Law and Crime Report. My name is Bob Bianchi. I'll be your host. A legend in the Supreme Court is now dead, leaving open a vacuum of political controversy with regard to her replacement, Ruth Bader Ginsburg, a trailblazer by all estimations, and it's really a mournful loss. But unfortunately, it's being eclipsed by the political dynamic here. I've listed about 5 things that we have to be concerned about, whether Republicans are going to go back on their 2016 promise that they will not nominate a person to the Supreme Court during an election year. You may remember in 2016, President Obama's Merrick Garland was denied a hearing by the Senate. It looks like they're going to go forward with it. Nevertheless, some are calling that hypocrisy, because the Republicans are having a different track with that, making fine line distinctions as to the difference between Merrick Garland and the new nominee. It's not clear if the nomination process could be finished before the election. We'll have to wait for that. And there are election-related disputes that could occur in this case. And if a new Supreme Court justice goes there, it'll certainly be a benefit to the Trump administration, some opine. This is not also to look at the fact that there will be fundamental changes in the law that's going to occur with that. I've ticked off a couple that I can think of off the top of my mind, including abortion, the Affordable Care Act, where they currently have a case right now trying to eliminate the pre-existing conditions rule, as well as LGBTQ rights, gun rights, and so many other issues. So Ruth Bader Ginsburg served her country well. Flags are at half-mast in federal and states throughout the United States for her service. The replacement is certainly going to be a firestorm election issue for both Democrats and Republicans. Let's switch gears, though. We have the new case here. There's Danny Masterson. He's 44 years old. He is the star of That 70's Show, where he played Stephen Hyde and The Ranch. He is charged with rape. There have been numerous motions that have been filed in court, including precluding the media, trying to get the case thrown out for probable cause. Famous people have been there, including Leah Remini. Now, you may know Leah Remini from King of Queens. She used to be a former Scientologist and has a show about that right now. It's been very critical of Scientology. And the reason that's important in this case is that both Mr. Masterson, as well as some of the victims, were with the Church of Scientology, and some of those victims claim that the Church of Scientology has tried to quell or quash this case from going forward against Mr. Masterson. We have the honor of having with us Kary Antholis. He is a crime story podcast. That's his podcast, Crime Story, former president of programming at HBO. His overview of stories has received Academy Award nominations and wins and Emmys and Golden Globe projects that he's been involved in. He's just really prolific that way. He's on the board of visitors at Georgetown Law. He's an adjunct professor. He's got a JD. He's got it all. Welcome to the show, Kary.
Thanks, Bob. Thanks for having me.
Yeah, happy Monday. So a couple of questions here right now. One of the first questions I have is that these cases stem way, way back that are being brought forward. And of course, any lawyer that's looking at that is wondering about statutes of limitation and how it is that a case like this can proceed. Can you enlighten us about what's happening there in court, the arguments on both sides for this?
Yes, I haven't heard the arguments about it yet, but I did do some research about it because I had those same questions. Apparently, a few years ago, the state of California changed the statute of limitations for the crime of forcible rape. That statute of limitations used to be 10 years. The law, but when they changed that law, it only allowed cases to go forward that were ripe as of 2017. So in other words, going back from 2017, you go back to 2007 for such crimes. But apparently, the statute of limitations does not and has not applied to crimes that carry a life sentence. And Mr. Masterson is accused of having committed 3 forcible rapes in the indictment. The dates of those rapes are 2001 and 2003. But because there are multiple counts, that carries a life sentence and therefore is not subject to the statute of limitations, according to my understanding of the California law.
Excellent description. Surely going to be something that I imagine the defense is going to battle. Let's take a listen to Judge Miguel Espinoza with regard to this case.
Your attorneys may appear in court on your behalf without you present.
Yes, Your Honor.
Do you also understand that you must be present anytime the court orders you to be present for any substantive hearing, for any preliminary hearing, for any trial, and for any disposition in this matter?
Yes, Your
The
Honor.
977B waiver form has been lodged and is accepted. Counsel, is it your intention to appear pursuant to 977B at the demurrer hearing?
Yes, Your Honor.
Mr. Masterson, your attorneys have filed a demurrer in this case. I have just set a briefing schedule. That demurrer will be litigated very likely at the next court date. Do you understand that you have the absolute right to be present at that hearing and give up that right and agree that your attorneys can appear on your behalf?
Yes, Your Honor.
And the 977B has been lodged and is formally accepted. That is pursuant to the emergency court rules adopted by this court in early April.
Okay, so let me ask you, Kary, what is the atmosphere like in this courthouse? I come to understand that about 20 friends and supporters were there. And as I mentioned before, Leah Remini is there. That's an interesting little twist. Talk to us about that.
Well, yes, in the hallway outside the courtroom was as full as anyone had seen it in, since before COVID. There were a lot of people there. Everyone was wearing a mask. People were trying to keep social distance, but there were also some security precautions made just before the hearing got underway. And it was not entirely clear initially why they were making those arrangements. But as it turned out, it was to usher in the alleged victims in the case. They were guided in by a separate entrance through the stairway and sat in a corner of the courtroom where cameras couldn't catch them and where their anonymity was preserved.
Right, so I understand that Masterson is requesting a demurrer hearing. Can you advise our audience what a demurrer hearing is?
Yes, as I understand it, it's not an assertion as to the facts of the case, but it is an assertion that the case itself is invalid according to California law. I imagine it might have something to do with the statute of limitations, but because the paperwork was only filed on Friday, we have not yet been able to get the paperwork. I hope to get that later today, and I can follow up with you on that down the road as to what exactly the grounds are. But yes, Masterson's arraignment was postponed until October, until after the demurrer motion is argued.
Okay, excellent. Let's listen to throw to a clip of the prosecutor in the case. That's Reinhold Muller, and what he had to say.
Would have a reasonable likelihood of prejudicing this case. We obviously share that concern and that interest with the defense. However, this protective order, as it's currently drafted, as it's constructed, is objectionable. First of all, it's overbroad. It's grossly overbroad. And I think it asks this court to exercise jurisdiction over parties, third parties, that is beyond the scope. So it needs to be more narrowly tailored. I think as it's written, it's grossly overbroad. And again, I think also premature, since counsel has not yet reviewed the evidence. They don't know what it's contained and what their order is asking to limit in terms of the disclosure.
Now, there's also, from what I understand, a defense motion here to prohibit discovery from being released to the public. Can you talk to us about that?
Yes, and in fact, that's what the prosecutor was arguing against there. Before we even were able to begin to record, there was a motion to keep cameras out of that hearing. the judge denied that motion, but in the course of the arguing it, Mesereau said, you know, the allegations and the public spectacle of this would prejudice a jury pool against his client, and the protective order was to prevent discovery from being leaked to the press, and therefore further prejudicing potential jurors against Mr. Masterson. The judge denied the motion to keep cameras out of the courtroom, obviously, and he also denied the motion, but allowed Mr. Masterson to retain the right to object down the road. As you know, there have been problems with the sheriff's department here leaking photographs of crime scenes, and so I believe that's why, you know, he was making that. That's part of what fed into making the claim, but mostly I think it's just to preserve his right to an impartial and unprejudiced jury.
Well, Kary, Mr. Mesereau has been known to be a person that has never shied away from cameras in other high-profile cases he's handled. So all of us are kind of questioning, like, why in this case? Do you think this has anything to do with Leah Remini being in that courtroom?
Well, there was a reference made by Mr. Mesereau to a producer who is an anti-Scientologist producer that was in the courtroom planning a planning a documentary about the project, about the case. And I assumed that he was referring to Ms. Remini. Yes, the Church of Scientology and is very protective of its image, and I think Mr. Mesereau is, you know, very aware of prejudice against the church, and was trying to protect his client on that front. It honestly was very understandable to me, but as the judge pointed out, this is a case of high interest. Sexual assault is a very serious allegation, and the judge sided on the side of providing light rather than darkness.
Now, we had the 3 victims in court that we noted before. There have been allegations that the Church of Scientology has, at least with respect to some people involved in this investigation, surveilled them, been looking in their windows, trying to pressure them, if you will. That's the allegation being made. Very consistent with what Leah Remini has said previously about Scientology. Did you see them connecting at all in that courtroom, Leah Remini and those victims? Was there a closeness or a symbiosis between them, or were they completely separated and didn't have contact with each other?
I did not notice that. In fact, I didn't even know that Leah Remini was in the courtroom until someone mentioned it after the fact. And then I looked at the footage and realized that if you go back to the footage you had up of the prosecutor in the case, on his over his elbow is a woman that looked to me like Leah Remini, but I didn't realize it until after the fact. But to your point about the Church of Scientology, the 4 victims have come forward, and I believe 3 of them are included in the criminal indictment, but 4 victims have alleged that the Church of Scientology and Mr. Masterson covered up and tried to intimidate, bully, assault these victims in a civil case that was filed last year. And included in those allegations are that a dog was poisoned, one of the victims' dogs was poisoned, and so the intimidation tactics are part of this, or the alleged intimidation tactics are part of a civil suit that's going on in Los Angeles civil court right now.
Right. Of course, the criminal defense attorney is saying that that civil suit proves that this is a money grab. Kary, Antholis, Crime Story Podcast. How do we find you?
Well, crimestory.com or the Crime Story Podcast on Apple Podcasts, Spotify, or wherever you get your podcasts. And also, I have a podcast called Jury Duty, The Trial of Robert Durst, which is also up on all of your podcast locations. Well,
Kary, you know the Law and Crime Network likes to do it gavel to gavel and get deep into these stories. Having somebody like you be able to illuminate this particular story is greatly appreciated. Thank you, sir. We have to take a break here. You got it. We have to take a break here at the Law and Crime Network. We got a lot of great stories and great guests coming up. Stay with us. We'll be right back. Okay, let's switch some gears here at the Law and Crime Network. We're talking about Joseph Oberhansley, who was found guilty of murder and burglary, but not guilty of rape of Tammy Jo Blanton, or Blanton, I apologize, who was the victim, an ex-girlfriend. We want to throw to a clip right now of him coming out of the courtroom after he was found guilty.
Not guilty of the charge. Two black male suspects killed Tammy.
Well, that's that. From the courtroom into that hallway, that's how they go, and then into a jail cell. I have with me Cheryl Dorsey. She is retired, a retired sergeant from the LAPD, a police expert, social justice advocate, media commentator, and analyst, author, and Mike Koribanics, a former prosecutor, assistant prosecutor, certified by the New Jersey Supreme Court as a certified criminal trial attorney. He is a media contributor and a legal analyst here at the Law and Crime Network. Welcome to the show, guys.
Thank you.
Okay, listen, this case was really something. So let's go through it. He's 39 years old from Indiana. Was guilty of, like I said, murder and burglary, not guilty of rape. The prosecutors allege that he raped, killed in 8 parts of her body. The defendant still maintains his innocence. The investigation was rather thorough, and I will say that there were some disputes that we can get into a little bit between the lawyers, but he was not competent for many years, which prevented him from going to trial, and the lawyers wanted to assert an insanity defense. He personally had that motion withdrawn, so there was the friction. He was saying, I didn't do it. That was his story. He took the witness stand. He was cross-examined. He was found guilty. So let me start with you, Mike. With regard to a case of this nature, when you have a defendant who is not listening to the advice of his attorneys and wants to go forward with it, talk to us about that little tension there and about how in the end, assuming it's not unethical, what a lawyer's responsibilities are to do when you have a conflict with your client like this.
It's extremely difficult, Bob, and it's so difficult to generalize on these type of conflicts because of the fact each one is so unique in its own way. The one thing, though, that really I found troublesome in some of the research I did regarding this case is my understanding is, according to one report, is his attorneys made a deal not to put up an insanity defense as long as the prosecution did not go after the death penalty. I don't know how this is going to stand. This is a horrible case, but I don't know how this verdict is going to stand when I don't really know how you could give away a defense, not in a plea bargain, but in just to remove a death penalty. I think it's going to be very troublesome, very, very troublesome. But in an insanity defense, one of the reasons why we do have experts is that the court should be alerted that this person isn't even competent to follow my advice. It's not as like, if he's not competent, how could he effectively waive a defense? I think that's going to be troublesome.
Right, and there's 2 different issues with that, Mike. I just want to follow up. Competency and insanity are 2 different things. Competency is whether you can assist your counsel. It's a very low threshold. It's essentially, do you know who the judge is, the prosecutor, defense lawyer, and that was held up for years. But that doesn't necessarily mean at the time of the event that he was legally insane, which is a very hard burden for the defense. But to your point, Mike, and I want our audience to understand this, they wanted to pursue the insanity defense. He did not. And in the end, they negotiated with the prosecutor, like you said, that, okay, if you don't file the death penalty, we won't file a defense. And I think what you're saying is an appellate court could look at that down the road and said he was denied an opportunity to present a defense, and that bargain should not have occurred. Is that what you're saying?
Yeah, that's what I feel. I feel it's a very strong issue, and I think it's going to be a problem.
So Cheryl, on the cop side of things, you were a prolific, officer. You know that inside and out, having retired from the LAPD as a sergeant. Talk to us a little bit about the investigative aspects of this case. There was an actual confession that was taken, and specifically when confessions are being taken, what do cops want to look out for in order to combat a potential insanity defense down the road?
Well, one of the things you want to avoid is trying to
have an optic that looks like you're coercing an individual into a confession. Oftentimes we hear that alleged perpetrators are questioned for hours and hours. You know, you could be kept up for, you know, half a day or an entire day being questioned, deprived of sleep and maybe food and Lord knows what else. And so sometimes you hear that people say, I would have said anything to just get out of there and be done with this. And so I think that's certainly one of the things that you want to be wary of. And then the other thing is to not put words in this person's mouth, to not be encouraging or again, kind of coercing them to say a thing that is not true. Because again, if you've kept them for hours, people will say and do anything to get from under the glare of an intense interrogation.
Excellent, excellent points, guys. Let's switch gears. We got a lot on the show today. Ahmaud Arbery is back in the news. The mom says that a fundraising effort's exploiting her son's death. It's kind of like a really bit of a twisted tale, but these people that started a registered trademark calling I Run with Maud. Remember, he was the individual that was jogging when 3 white men killed him. They're all indicted and being charged with murder and felony murder charges. And the mom is saying that they registered trademarks. They started a GoFundMe, a Facebook page in his name, and that she did not want to monetize this at all. She wanted this to be used in his memory and to advance social justice issues. Nevertheless, they have now changed those people. Jason Vaughn was his former football coach. And they've changed that now to a new 501 organization, which is the 2:23 fundraiser or foundation rather, which I guess denotes the 2.23 miles he ran before he was shot and killed. The mother is really upset, saying, "They have known for months I did not want my child's death exploited or used for monetary gain for anyone. I was disrespected," and she is extremely upset. Cheryl, if these things are accurate, it looks like some people are trying to profiteer on her son's memory and make money. And she was saying that that is not what this is for. What are you getting from all of this from your research?
Well, listen, it sounds to me the same way because there's a lot of back and forth. They're changing the names of the fundraiser to their benefit. And if they were on the up and up, and if this was really about a grieving mother who lost her son and is deserving of whatever may come their way monetarily, they could change this in a nanosecond. Just turn it over to the mom and the dad and be done with it.
Mike, thoughts?
I couldn't agree more. You know, technology, while sometimes is good, it sometimes makes our life much more complicated. I think out of respect to this family, that GoFundMe page should be dropped, or whatever they request, since it is their son's name that they're trying to use, they should follow the family's wishes.
Yeah, and guys, you know, these GoFundMe pages, while they provide a great service, like anything in technology, to Mike's point, can be abused. So it's very, very important that a consumer is vetting who's running this and where is this money going, because we're seeing more and more scams of this kind of nature. And I'm not suggesting this is a scam, but it's clear the mother is not happy. Cheryl, how do we do our due diligence to make sure that we're contributing to the right place?
Well, you should always check before you give over funds. And certainly, you know, if you've never been through this, if you've never lost a loved one and you're not savvy in the way of trademarks and 501c3s and fundraisers in the name of, it happens routinely because people want to help. People are caring and compassionate and concerned, and you want to do whatever you can to minimize that grief and help sometimes just with the simple fact of burying a loved one. And so it's very easy to take advantage, and now they've gone far beyond those first few days and weeks after his death into months later, continuing to victimize this family. And it's sad and unfortunate.
And Mike, just to be fair to the other side, although they have not given a lot of information, they are saying that this event became bigger than they thought, the issue's bigger than they thought, and this is the reason why they're doing what they're doing, but they're pretty much not addressing much of the mother's claims. So there is a possibility there's an angle towards that, but registering trademarks, that's pretty sophisticated. That's stuff that us as lawyers who have stuff that can be trademarked don't even really do.
It's funny you say that, because when I was reading about this, I was saying I didn't even think about the trademark aspect on a GoFundMe page, because I think most people with GoFundMe really get led with their emotions. And I think certain people capitalize on the fact that you really shouldn't have to consult your lawyer to make sure that you're giving the donation to the proper place.
All right, guys, excellent commentary. A lawyer pleading guilty to a 30-year charge for the killing of his son. The mother's already doing a significant prison sentence. It's really a fascinating story. If you want to hear it, stick with us here at the Law and Crime Network. We'll be right back. Okay, out of Illinois, Andrew Freund, Sr., has pled guilty to his role in the death of his 5-year-old son, AJ. And the counts that he pled guilty to were 1, 14 years for involuntary manslaughter, 11 years for aggravated battery, and 5 years to concealment of homicide. Listen to this, because it's going to be an important fact. Their sentences are to run consecutively, which means one on top of the other, or stacked, as we call it in the profession, which gives him a 30-year sentence for his plea. His wife, Miss Cunningham, was given, Joanne Cunningham was given 35 years in prison after a plea to first-degree murder. Let's take a listen to Judge Robert Wilbrand with regard to this case.
Mr. Freund, understanding the charges against you, the possible sentences, and the proposed negotiations in your case, do you wish to enter into a negotiated plea of guilty at this time?
Yes, Your Honor.
Did you have enough time to talk with your attorney about your negotiated plea, and are you satisfied with the services?
Yes, Your Honor.
Are you under any disability now, either medical, mental, physical, or otherwise, that would prevent you from understanding the terms of your negotiated plea?
No, Your Honor.
All right, let's take a look at that. Andrew Freund Sr., the person you just saw there, is an attorney. He pled guilty to 30 years. He's a 60-year-old man. He called police on 4/18/20, saying, reported his son missing, his 5-year-old son missing. Police found a chain lock to keep AJ locked in his room. Police say that the father described a stressful home life, that AJ was stubborn and headstrong, and that they would put him in his room and where he would just be lying there because of his egregious lying. The defendant admitted to spanking AJ hard at times. The defendant, to keep Cunningham from hitting him, she prevailed upon him to put him in the shower where she was dousing him with water. As AJ was questioned, Mom forced shower nozzle into his face. The defendant says he intervened and put AJ to bed, and AJ later dies. The autopsy report comes out that he had blunt force trauma, blood in his lungs, abrasions on his forehead matching the shower head, and that he died. The cause of the death and manner of death was homicide from head injuries that were his cause of death. Mike, let me go to you first on this. What I found particularly interesting is that there is no death penalty in Illinois. And there was the wife who's doing a 35-year sentence, who was the person who was actually perpetrating the incident, the shower incident that led to the child's death. And the defendant's story was that he interceded and took the child away, and the child later died. I don't know, we don't know all the permutations and all the considerations, but that's essentially a life sentence for him, given what we know. And I've been in this position before where prosecutors have offered something like this, where I've said, I'm not pleading up to something like that. I'd rather go to trial and lose it. What's the difference? 30 years, 50 years to a 60-year-old guy, it makes a little difference. You're going to have to take it from me before I give it to you. What are your thoughts?
You know, Bob, I agree with you, and that's a lot of our thoughts, but always it's ultimately up to the client. Perhaps this defendant or this client came to the point in time where he put legality aside, and just as a matter of conscience and his humanness came through and said, you know what, I need to be punished through this. I don't want to hear about how my son died again and how I am responsible for it. I'd like to put this behind me and move forward and accept responsibility.
I've seen 1 in 1,000, Cheryl, that may feel that way, but I would always say to them as a defense lawyer, look, that doesn't mean you don't have to accept the responsibility, but we can maybe get a 15 or a 10 or a 5 or some number where at least you can get out and have a cognizable life. What are your thoughts about the way this rolled? I'm not buying I want to do a lot of time just because I'm wrong.
Well, it may very well be given his age, and who knows, maybe he's predisposed to some kind of medical condition that we're not aware of, and he may not be here much longer anyway. And to the other guest's point, maybe he just decided, I need to be punished. This is a terrible, terrible thing that they did to a 5-year-old. I mean, aside from, saying that he's an egregious liar at 5, they punished, tortured this small child. He's an attorney, and he's interceding on behalf of the mom, allegedly, and then they bury this baby. I have little sympathy for him. And for me, I don't care if he is 55 or 60, 30 years isn't enough for me.
Yeah, well, the wife gets, 35, and she's the one who actually did the act. Yeah, maybe child endangerment. I mean, the prosecution has to prove that he had a shared intent. I'm talking about legal stuff here, not the morality of whether it's right or wrong. But those are obviously fair arguments to make. The statement of the crimes were read out loud by the prosecutor of court. Let's go to Patrick Kary, who was the prosecutor in the case.
Defendant Freund indicated that he was woken up by Defendant Cunningham at 3 a.m. on April 15, 2019, and was told by Defendant Cunningham that AJ was not breathing. After realizing that AJ was dead, Defendant Freund indicated that he told Defendant Cunningham he would handle it and placed AJ's remains in a large plastic tote in the basement. Specifically, Defendant Freund stated. Defendant Freund. So I attempted to resuscitate him Monday night, and I know we dressed him and tried to get him warm, but I don't obviously that didn't work. Defendant Freund. So anyway, I carry him downstairs, and we left him downstairs until Wednesday night, April 17, 2019. Police, where downstairs? Friend, there's like a big plastic tub, I don't know what's in it. Christmas decorations or so, I don't remember what was in it. Just placed down on there. The boys weren't allowed down there, so there wasn't a risk that PF. Defendant Freund. All right. So I put in a couple of plastic bags, and I put him in the trunk of my car and drove him out. Obviously, I will show you where that is. On April 24th, 2019, Defendant Freund led authorities to AJ's body, which was buried in a shallow grave in rural Woodstock, Illinois. A subsequent autopsy performed by Mark Wittick, forensic pathologist, revealed multiple blunt force injuries to the head, torso, and extremities, including A, severe swelling of head, soft tissues, multiple bruises and abrasions. B, severe swelling of the brain. C, multiple abrasions and contusions of torso and all 4 extremities. D, bilateral inhaled blood in the lungs. Pattern injuries, of small circular abrasions on the central forehead. These circular abrasions match the pattern of the detachable shower head spray face. If called to testify, Dr. Wittick would testify that AJ died of craniocerebral trauma head injuries due to multiple blunt force injuries to the head. If called to testify, Dr. Wittick would testify further that AJ's injuries were consistent with child abuse and not consistent with hypothermia or falling.
Yeah, so Mike, I'm going to press this point with you a little bit. Endangering a bad environment, all of that, guilty, concealment of the remains, guilty. But it looks like that this child was actually beaten. And the question becomes whether or not he either was a participant in that or he allowed that to occur. That would be an essential element the prosecution would need to prove at the trial. And that fact could be in dispute, although, of course, we have not seen the confession, and we always have to comment on these things. But it's not just that he died and that he should have done something and therefore you should get 30 years to life. It's about meeting the elements of each crime and the state being able to prove that beyond a reasonable doubt. Again, unless he had that twist of heart in your mind that he wanted to just give in and do time, which is a very, very unique thing for a defendant to do. Pleading him guilty to the things he's responsible for is one thing, but he's pleading guilty to the whole enchilada here.
Well, I think on the other hand, Bob, there might have been a position where the government said, listen, this is as low as we're going to go, so you make your decision. It just seems, Bob, that this is a child's father. He allowed his child to die. I think at a certain point in time, according to his confession alone, I think they had a very strong case to show that he contributed to the death, how could you say you put a child to sleep and you thought everything was all right when they're saying that the autopsy showed there were marks, there were visible bruises, bleeding in his lungs, things around his mouth that matched the shower nozzle. I don't think this was a strong case for the defense, Bob, and I'm usually very pro-defendant, as you know, and I think this was just something where his lawyers had to say, do you want to sit through this and listen to what you did again? And he chose to maybe hope that he can have a few years of life left, but it's very difficult, as Cheryl said, to be sympathetic to this defendant.
Cheryl, as a retired LAPD person who's done so much work in the field, let me ask you, based upon your overall career, are more of these cases occurring that we see with the brutality of children? Is it different today than it was 20, 30 years ago? Or are we just becoming more attuned to it because of the coverage and social media and things of that nature?
I don't think that there's necessarily more. I think that this has been something that's always been going on, and I think there have been some pretty high-profile cases where Department of Children's Services neglected to intervene, didn't do what they should have done because of whatever they purport, overworked caseloads, something that they didn't see. I would imagine that this is probably not the first time that these parents have put hands on that small child. You don't start off smacking your kid in the head in the shower for punishment with a nozzle for a shower head the first time he angers you. And so, like everything else with the advent of technology and just stuff that goes on in the news, it seems like this is something new and different when people have been abusive and taking advantage of small children for a long, long time, sadly.
Very sad indeed. Very well stated. Cheryl, Mike, thank you so much. We're going to go to a real quick break, but we still got a lot more here on the Law and Crime Network, so stay with us. I'm your host, Bob Bianchi. We'll be right back.
You have detained women. I had several detained women on numerous occasions that would come to me and say, Miss Wooten, I had a hysterectomy. Why? I had no answers as to why they had those procedures. And one lady walked up to me here this last time around between October of 19 until July the 2nd. And she said, what is he? Is he the uterus collector? Does he collect uteruses? And I asked her, what does she mean? And she says, everybody that I talked to has had a hysterectomy.
This has been an amazing story. I mean, when the allegations came out by that nurse that you just saw there, Dawn Wooten, and the complaint that was filed, it is talking about mass hysterectomies. Ms. Wooten at one point indicated, quote, everybody's uterus can't be that bad, and that he, referring to a medical doctor performing these hysterectomies, is a uterus collector, and that this was well known, and that because she was complaining about it, she was later demoted, and she filed this whistleblower complaint. Guys, I want to talk to you a little bit about this because they're saying that migrant women have come forward alleging they did not agree or fully understand the procedures that were being done, and the lawyer that filed the complaint from the Project Southern Lawyer indicated that she put in the alleged mass hysterectomies to trigger an investigation. She spoke to the Washington Post, and she included that the hysterectomy allegations that she brought were to trigger an investigation. That she filed this complaint to trigger an investigation, quote, I have the responsibility to listen to the women I have spoken with. And she indicates that she wanted to make sure that these people were not pressured into hysterectomies, some of which include they were under surgery for one thing, and then their reproductive parts were taken away without their consent, which some doctors say is a violation of U.S. law that requires that you close the person back up and get informed consent before you sterilize essentially these women. But the Associated Press indicated in an article that it does not find evidence of mass hysterectomies at the ICE detention facility. So, Cheryl, talk to me about what your feelings are about this. There seems to be some conflicting information here. But I mean, if any of this part of these allegations are true, that they did not know full and informed consent, and they're having their reproductive organs removed, whether it's one or many, is bad.
Absolutely. And listen, the fact that the Associated Press hasn't found evidence doesn't mean that evidence doesn't in fact exist. And listen, this is a real easy fix. And I would imagine that before the attorney brought this forward, there was probably a medical exam for anyone who made such an allegation to determine whether or not their reproductive organs had been removed. And for the whistleblower to come forward, that takes tremendous courage for her to do that, understanding that there was going to be repercussions, and she's since been demoted. There's no benefit in her making this up because it's easily proven or disproven if she were saying something that wasn't true. It's outrageous.
Yeah, it's really kind of hard to believe, but in today's environment, just who knows, especially with respect to the horrific treatment that these folks in ICE detention have already received, inhumane by the definition of many people. Mike, one of the lawyers that kind of commenting on this and potentially assisting in this lawsuit is indicating that one of the goals that they want to have is that they want investigators to look into the systemic lack of transparency with regard to informed consent, and also mentions that these women aren't even given an opportunity at a second opinion. Now, I know a lot of people may balk at this that watch the show, but the fact is it's just like prisoners in a jail. Regardless of what your politics are, when you are in the custody of the federal authorities, these women are extraordinarily vulnerable. There's language gaps. They're potentially not being informed of all the consequences. So I do believe if a full and fair investigation goes, is clearly needed here. It's bad enough that some of these parents have lost their children that they're never going to be repatriated with. They're now being denied the opportunity to ever have children again. Thoughts, Mike?
This whole story, I think as the sergeant pointed out, and being so experienced in law enforcement, is you can't get an answer to a complex question in a simple few days. This takes an enormous amount of investigation. You would hope it wouldn't. You would hope internally there'd be checks and balances so it wouldn't get to be to this point. But I think right now all need to investigate and represent their interests, meaning the ICE needs to do their own investigation. The lawyers representing the whistleblower and other alleged victims need to do theirs. But there's not going to be an answer to this question in a week or two. Investigation, I mean, lawyers, we usually are at the end of investigation, as a sergeant would tell you, is they're on the ground doing the work, and it takes time to go through medical records for one person, let alone the a huge amount of people they say were victims here. So I think this investigation needs to proceed accurately, slowly, and very, very meticulously.
Yeah, and the nurse, obviously you can look at the credibility of the nurse, and she put herself out on the line, like Cheryl said. Cheryl, what about the idea that there are some in the community, a lot, I would say, in the country, that don't even trust investigations any longer coming out of the federal government? Is there a fair point there?
Well, certainly, there's always the presumption that you can't trust an entity to properly investigate itself because you understand where their loyalties lie. And so I think if you want to really put this thing to bed, if you will, then you'll have an independent party who's going to be able to look at this objectively and come to a conclusion and then let the chips fall where they may.
Yeah, Mike, go to the same point with the investigations, everything that we've seen for the last couple of years. It's hard to trust anything when we have our political establishment indicating that federal investigators can't be protected. And we've seen from our standpoint things that are done that are very, very odd with regard to investigations and a lot of political interference. Thoughts?
My thoughts are that's where you need effective advocates. I couldn't agree more that you need independent judgment, which hopefully the courts come to, but you need to represent your client and you need to continually check the government if you are suing them in their investigation, and you need to demand independent investigations as well.
And to the point, how can they really have effective advocacy? Real quick, guys, I'm going to give you each an answer to answer this. When they're marginalized to begin with, don't have the right to second medical opinions, and these lawyers have so many clients, how can they properly address each one with the intensity this kind of investigation would need? I need 10 seconds from you, Cheryl. Mike, Cheryl first.
There's certainly groups out there that are working with these people and helping them now, and so they'll continue to do that.
Mike?
Like a marathon, Bob, you start it one step at a time. You just have to go to the problem in front of you and take it one at a time.
All right, Cheryl, Mike, I want to thank you so much, guys. Thanks for sticking with us. Have a great week. You can find me at RBianchi ESQ. Stay with us for a regularly scheduled program. Have a great week.